This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the use of electronic notices, email notices of renewal or non-renewal of policies, premium charges, all by email or by some other electronic means, and why, when you get such a notice, if you fail to timely pay the renewal premium, your policy will lapse. And renewal notices sent electronically are legal, approved by the state, in this case the state of Washington, and are effective. Washington state law allows insurers to deliver insurance policies and documents electronically if the party has affirmatively consented to that method of delivery and has not withdrawn the consent. The plaintiffs argued that the terms and conditions statement was not conspicuous because it was hidden behind a hyperlink included in a single line of small text. The court found that the statement was sufficiently conspicuous as it was bolded and set off from the surrounding text in bright blue text. In the case entitled James Hughes et al. Versus American Strategic Insurance Company et al., the United States District Court on February 14, 2025 resolved the dispute. The court's reasoning focused on two main points. One, whether the plaintiff consented to receive electronic notices, and two, whether the notice provided by ASI satisfied Washington law. The court found that the terms and conditions statement was clear in informing the plaintiffs that they were consenting to receive insurance policy documents electronically. And we all seem to now get the entire policy as a PDF document electronically if we ask for it instead of big chunks of printed paper. Whether the notice satisfied Washington law requires insurers to renew any insurance policy unless they have communicated their willingness to renew in writing to the named insured at least 20 days prior to its expiration date and included a statement of the amount of the premium required to be paid by the insured to renew the policy. The USDC found that ASI's renewal notice, which was emailed to the plaintiffs on July 15, 2022, complied with these requirements because the notice came 61 days before the renewal deadline and stated the amount required to be paid to maintain the policy. The United States District Court noted that although ASI's system of attaching renewal notices in lengthy packets, probably containing the entire policy, was not ideal, but it did not violate the law. The court also noted that insureds in Washington state have an affirmative duty to read the policy and be on notice of its terms and conditions. A renewal premium notice was contained in the packet attached to the email. In relevant part, the notice stated, quote, "To accept this renewal offer and maintain your coverage, please pay the minimum amount due shown below." Close quote. The notice listed, quote, total amount due as $1,471 and listed September 14, 2020 as the due date. Plaintiffs did not pay the renewal by September 14, 2022, and the policy lapsed. And in addition, the insurer wrote to the plaintiffs and told them your policy has lapsed. Plaintiff's house was destroyed by a fire on August 11, 2023, almost a year after the due date, with no attempt made by Mr. Hughes to pay the premium. When Mr. Hughes called to report the claim on August 12, 2023, he was informed the policy had lapsed. Plaintiffs alleged that they incurred over $750,000 in damages for the loss. The USDC noted that the plaintiffs were actually aware that they were receiving renewal notices by email. Indeed, the Terms and Conditions statement uses the word insurance policy documents 3 times, making it clear that the types of notices and documents contemplated are those that pertain to the signor's insurance policy. Mr. Hughes confirmed receipt of the July 15, 2022 email containing the renewal packet. The renewal premium notice in the packet instructed plaintiffs to pay the minimum amount due to maintain their coverage and listed the total amount due. Since the notice came in 61 days before the renewal deadline, not the shorter 20 days allowed by statute, and stated the amount required to be paid in order to maintain the policy, it complied with Washington state law, and plaintiff's policy validly lapsed when Hughes did not make the renewal premium. In my opinion, Mr. Hughes agreed to accept all communications from ASI electronically and admitted that he received the communication stating when and how much he needed to pay to renew the policy. He did not pay the premium, and the policy lapsed. ASI even wrote to Hughes about the lapse, and he did nothing to renew the policy or find a new policy. I would feel sorry for the man if he did not receive the notice, but he admitted he received it and claimed that the premium requirement was hidden from his view, even though it was made bold and in a bright blue color. Also, ASI and his insurance agent wrote to him to explain the lapse, and he had no one to blame for the lapse of his policy coverage except himself. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you will receive notice of every blog posting, usually 5, sometimes 6 a week, and you will also gain access to the more than 5,000 blog postings. You can also subscribe to the videos. They're also free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in more detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.